In this lecture, we're going to be covering chapters 25, 26, and 27. Chapter 25 discusses defenses. Limited defense versus a universal defense. A limited defense is limited to being raised against any holder, and it is not effective against a holder in due course. A universal defense is effective against all holders of a negotiable instrument, including a holder in due course. Classification of defenses: limited personal defenses. The first would be an ordinary contract defense, such as a failure of consideration, failure of performance, consideration was illegal. Fraud, such as fraud that induced the execution of the negotiable instrument. For example, one was persuaded to sign a negotiable instrument because of a false representation. Conditional delivery, for example, the negotiable instrument delivered on the condition of a specific performance. Improper completion, any part of the negotiable instrument is left blank. Payment or part payment, if the negotiable instrument is not surrendered or partial payment is not recorded, the only recourse is against the holder of the negotiable instrument. Limited defenses: one would be non-delivery. If one person makes out a note to another person and that other person takes the note from the maker's desk without the maker's permission and negotiates it to an innocent purchaser or holder in due course, the holder in due course would be entitled to recover the amount the note against the maker was made out for. This applies in spite of the non-delivery of the note. Theft: a thief may not normally pass good title. However, an exception occurs when the thief conveys an instrument to a holder in due course. An example of ordinary contract defense: if Smith agreed to paint Jones's house but did not do it properly, Jones would have a right of action against Smith for breach of contract, or Jones could refuse to pay Smith the price they had agreed on. If Smith assigned the right of payment, Jones would be able to raise the same defense against the assignee, which is the person that Smith assigned payment to. However, if Jones paid Smith by check before the work was completed and the check was negotiated to a holder in due course, Jones could not defend on the ground of failure of consideration. The check would have already been paid. Jones's only right of action would be against Smith for the loss. An example of fraud in the inducement in regards to a negotiable instrument: if Randolph persuades Drucker to buy a car because of false statements Randolph made about the car, and Drucker gives Randolph a note for it that is later negotiated to a holder in due course, Drucker cannot defend on the ground that Randolph lied about the car. Drucker will have to pay the note and seek any recovery of damages from Randolph. An example of conditional delivery: if Sims makes out a check for buyers and delivers it to Richard with instructions not to deliver it until buyers deliver certain goods, but Richard delivers it to Byers, who then negotiates it to a holder in due course, Sims will have to pay the negotiable instrument. Classification of defenses: universal defenses. Minority: a minor may avoid agreements under contract law. Forgery: fraud as to the nature of the instrument or its essential terms. The defense that one was induced to sign an instrument when one did not know that it was in fact commercial paper is available against any holder. So for example, if an illiterate person was induced into signing something and they didn't know that it was a check, that's a universal defense. Discharge in bankruptcy proceedings is also a universal defense. Hybrid defenses: duress. When the duress nullifies a contract, the defense is universal. When the duress merely makes the contract voidable at the option of the victim of the duress, the defense is a limited one. Incapacity other than minority: if the effect of the incapacity makes the instrument void, a nullity, the defense is universal. If the effect of the incapacity does not make the instrument a nullity, the defense is limited. Illegality: illegal transaction is paramount to a limited defense. Illegal instruments would give rise to a universal defense. Alteration: the unauthorized change to an instrument. The party affected by the alteration is discharged from the negotiable instrument. Any defendant may raise these defenses: a suit not brought in the proper court, no service of process existed, the statute of limitations has run and bars the filing of the suit. Any defendant on a suit of negotiable instrument may raise these defenses: the instrument is not negotiable, the plaintiff is not the holder, the defendant is not a party liable for payment of the paper. Let's go through our chapter summary questions. Explain the difference between a limited defense and a universal defense. A limited defense is a defense that is not effective against a holder in due course. A universal defense is effective against all holders, including a holder in due course. Question 2. When is there fraud in the execution of an instrument? Fraud in the execution of the instrument occurs when a person knows a commercial paper is being executed and knows its essential terms, but is persuaded or induced to execute it because of false representations or statements. Question 3. What should the party making payment of a negotiable instrument demand to ensure that the instrument is not further negotiated to a holder in due course who could require payment? The party making payment of a negotiable instrument should demand the surrender of the instrument to ensure the instrument is not further negotiated to a holder in due course who could require payment. Question 4. How can a person making a partial payment on a note be protected from a holder in due course subsequently requiring payment of the full amount of the note? A person making a partial payment on the note can be protected from a holder in due course subsequently requiring payment of the full amount of the note by making sure the fact of the partial payment is recorded on the instrument. Question 5. May a thief convey good title to an instrument? A thief may not normally pass good title. However, when a thief conveys an instrument to a holder in due course, such a holder acquires good title. Question 6. Is anyone liable to a holder in due course when an instrument has been forged? When an instrument has been forged, the forger is liable on the instrument to a holder in due course. Question 7. Under what circumstances is the defense of fraud as to the nature of the instrument and its essential terms unavailable? The defense of fraud as to the nature of the instrument and its essential terms is unavailable to competent individuals who negligently fail to read or give a reasonable attention to the details of the documents they sign. Question 8. When is duress a universal defense? Duress is a universal defense when the duress nullifies a contract. Question 9. Explain the effect of the defense of incapacity other than minority. If the effect of the incapacity makes the instrument void, a nullity, the defense is universal. If the effect of the incapacity does not make the instrument a nullity, the defense is limited. Question 10. May a person who takes a fraudulently altered instrument for value in good faith and with no notice of the alteration enforce the instrument? A person who takes a fraudulently altered instrument for value in good faith and with no notice of the alteration may enforce the instruments according to its original terms or to its terms as completed. Chapter 26, Nature and Creation of Agency. Nature of agency. Principal is the person who appoints another to contract with third parties. An agent is a person appointed by a principal to contract on behalf of another, usually the principal. Principal appointing agent results in contract of agency. Importance of agency. Agents are delegated by business owners for the important details of business transactions. Agents are necessary in order to bring one person into a business contractual relationship with other people. For example, a farmer who sends an employee to town to have a piece of machinery repaired gives the employee the authority to enter into a contract that binds the farmer to the agreement. So what powers may be delegated to an agent? An agent has all the powers the person who appointed them has. Courts will not permit certain acts of a personal nature delegated to agents. For example, voting, jury duty, and so forth. Agents cannot be authorized to act out against the law. In other words, to commit a crime. Who may appoint an agent? All people legally competent to act for themselves can act through an agent. A contract between a minor and an agent is voidable. Some states find this type of contract to be void. Who may act as an agent? Any person with sufficient intelligence to carry out the principal's order may act as an agent. Corporations and partnerships may also act as agents. An agent may require certain licenses for some types of transactions. For example, a real estate agent or an insurance agent. Failure to meet these requirements disqualifies an agent in performing his or her duties for those types of transactions that require a license. Classifications of agents. General agents are agents authorized to carry out particular kind of business or all business at a place. So for example, a bank cashier, a store manager, these types of agents can buy and sell, they can make payroll, collect on accounts, pay bills, etc. A special agent is an agent authorized to transact specific act or acts. For example, buying a house or selling an admission ticket is the role of a special agent. Other types of agents: factors. A factor is a bailee seeking to sell property on commission. Factors del credere. This is a factor who sells on credit and guarantees that the price will be paid. Brokers are agents with the job of bringing two contracting parties together. Attorneys in fact. This is a general agent appointed by written authorization. So, what is the extent of an agent's authority? A general agent has authority to transact several classes of acts. Acts clearly within the scope of the express authority given by the principal. Acts customarily conducted by that type of agent are within the agent's authority. Acts outside of express authority but appear to third parties to be within the scope of the agent's authority. This is referred to as the apparent authority of an agent. Express authority, authority of the agent stated in the agreement which created the agency. Implied authority, this is the agent's authority to do things in order to carry out the authority provided in the agency agreement, such as buying inventory to sell. Customary authority, this is authority an agent possesses by custom. For example, a cashier customarily makes change for customers. Apparent authority, authority an agent is believed to have because of the principal's behavior. For all your insurance needs, contact your local agent. That's a common slogan used by insurance agents that would lead a consumer to believe that the agent they're dealing with has the authority to write policies. Creation of an agency. Any of the following may create an agency: appointment, ratification, estoppel, or necessity. Creation of an agency by appointment. This is a common way to create an agency. The principal makes a statement to the agent. A contract may be written or oral, formal or informal. Power of attorney is a writing indicating the appointment of an agent. This type of creation of an agency must be notarized. Ratification is the approval by one person of the unauthorized act of another done in the former person's name. Requirements for ratification include the one who assumed the authority of an agent must have made it known to the third party that he or she was acting on behalf of the party who attempts to ratify the act. The one attempting to ratify must have been capable of authorizing the act at the time the act was done. Some jurisdictions apply this rule to corporations, so that a corporation formed subsequent to the time of the act cannot ratify an act of a promoter. Other states have ignored this requirement in regard to ratification of the acts of the corporation promoters. The one attempting to ratify must be capable of authorizing the act at the time the approval of the act is given. The one attempting to ratify must have knowledge of all material facts. The the one attempting to ratify must approve the entire act. The ratified act must be legal, although the person whose name was forged may ratify a forgery on commercial paper. The ratification must be made before the third party has withdrawn from the transaction. Agency by estoppel. Agencies arising when one person leads another to believe a third party is an agent. The principle is bound to the extent of the representations made for the purpose of preventing an injustice, such as unjust enrichment, to mislead the party. Creation of an agency by necessity. Relationship of agency may be created by necessity for one. For example, parents must support their minor children. Agency of necessity may also arise from an unforeseen emergency. For example, a bus driver may pledge the owner's credit to repair the bus so he can complete the transport of his passengers to their destination. Other employment relationships include independent contractors. An independent contractor is one who contracts to do jobs and is controlled only by that contract as to how to perform the job. Employer-employee relationships. The employee works for an employer. The employer controls what work the employee is to do and in the manner in which it is to be done. Let's discuss our chapter review summary questions. Question 1. What distinguishes an agency from other employment relationships? The making of contracts with third persons on behalf of the principal distinguishes an agency from other employment relationships. Question 2. May all acts be delegated to an agent? The courts will not permit certain acts of a personal nature to be delegated to others, so not all acts may be delegated to an agent. Question 3. May a minor make a valid contract appointing an agent? The contract by which a minor appoints an agent to act for the minor is normally voidable. However, some states find such contracts void. Question 4. Who may ordinarily act as an agent? Ordinarily, any person who has sufficient intelligence to carry out a principal's orders may be appointed to act as an agent. Question 5. What authority does a general agent have in addition to express authority? In addition to express authority, a general agent has that authority that one in such a position customarily has. Question 6. What classes of acts does a general agent normally have the authority to transact? A general agent normally has authority to transact acts clearly within the scope of the express authority, customarily within such an agent's authority, and outside of express authority, but that appear to third parties to be within the scope of the agent's authority. Question 7. When must the contract appointing an agent be in writing? The contract appointing an agent must be in writing if the agent is created to transfer title to real estate, is to last for more than 1 year, or is created to execute a formal contract. Question 8. What does ratification of an unauthorized act done in someone else's name do for the assumed agent? Ratification of an unauthorized act done in someone else's name puts the assumed agent in the same position as if there had been authority to do the act at the time the act was done. Question 9. When does an agency by estoppel arise? An agency by estoppel arises when a person by words or conduct leads another person to believe that a third party is an agent or has the authority to do particular acts. Question 10. When does an independent contractor relationship differ from an agency? The difference between an agency and an independent contractor relationship is in the degree of control over how the work is done. The difference between an agency and an employer-employee relationship is the degree of control exercised by the principal over the agent or employee, and that the agent has the authority to bind the principal. Chapter 27, Operation and Termination of an Agency. Agent's duties to the principal. This is otherwise known as the agent's fiduciary duty to the principal. The agent has the duties of loyalty and good faith, obedience, routine and discretionary instructions, reasonable skill and diligence. An implied warranty exists that the agent has the skill and diligence required to do what the principal asks. Accounting, deposits, any loss is the responsibility of the agent. Information, the agent must keep the principal informed about what's going on with the business. The principal's duties to the agent. Compensation, expressed or the customary pay. Reimbursement, the principal must reimburse when the agent uses personal funds to cover unnecessary business expense. Indemnification, this is payment for loss or damages arising from a lawsuit. Abidance by the terms of the contract. Agents' liability to third parties. Agents who contract in their own names and do not disclose the names of the principals become liable to the same extent as though they were the principal to the contract. For this reason, agents who sign contracts in their own names will be held liable. Therefore, the proper way for an agent to sign so as to bind only the principal to the contract is to sign principal by agent along with your endorsement. A signing of the principal's name alone will likewise protect the agent, although the third person may require the placing of an agent's name under the name of the principal, so that at a later date it can be determined which agent had obtained the contract. Agents may make themselves personally liable to third parties by an express agreement to be responsible. This express agreement may be demonstrated if it is the only logical or legal interpretation of the contract. People who presume to act for others but actually have no authority, or who exceed or materially depart from the authority they are given, incur personal liability to those whom they do business. The latter situation may arise when an overzealous agent affects what they may think is a desirable contract. An agent incurs personal liability for fraud or any other wrongdoing, whether caused by disobedience, carelessness, or malice, or whether committed on the order of the principal. The principal's duties and liabilities to third parties. Ordinarily, the principal is liable to third parties for contracts made within the actual or apparent scope and authority of their agents. An agent entering a contract not within the apparent scope of authority will not bind the principal unless the principal ratifies the agreement. Termination of an agency by acts of the parties. Original agreement may call for the agency to terminate on a specified date. There may be a subsequent agreement between the agent and the principal to terminate the agency. A revocation of the agency. This is where the principal terminates the agent, or a renunciation of the agency. This is where the agent leaves or quits being the agent of the principal. Termination by operation of law. If the agency becomes subsequently illegal, that will terminate the agency. Death or incapacity. An exception is a durable power of attorney, which is a written appointment of agency that becomes effective when the principal is incapacitated. Examples of this are healthcare decisions such as admission, authority for medical procedures, or life support. Destruction of the subject matter. For example, the house you have contracted to purchase burns down. That would terminate the agency between you and the real estate agent. Bankruptcy, dissolution of the agency. This is a complete termination of the agency, or war. Notice of termination. When principals terminate agencies, notice to third parties must be given if those third parties have transacted business with those agencies. The method does not matter as long as the third parties are put on notice. Let's cover our questions at the end of chapter 27. Question 1. In a contract of agency, are all the duties of the agent and principal specified in the agency contract? In a contract of agency, the law imposes duties not set out in the contract on both the agent and the principal to each other and to third parties. Question 2. Why does the relationship of agent and principal call for a higher degree of faith and trust than do most contractual relationships? The relationship of agent and principal calls for a higher degree of faith and trust than do most contractual relationships because the relationship is fiduciary in nature. Thus, the principal must be able to trust the agent to perform the duties according to the contract. Question 3. How obedient must an agent be to routine instructions from the principal? The agent must carry out all routine instructions to the letter, as long as compliance would not defeat the purpose of the agency, be illegal, or perpetrate a fraud on others. Question 4. What are the consequences if an agent deposits the money of the principal in a bank in the agent's name? If the agent deposits the money of the principal in a bank in the name of the agent, any loss caused by the failure of the bank will fall on the agent. Therefore, the agent is liable for the money at that point. Question 5. May an agent enforce a principal's promise to pay a bonus to the agent for information secured by the agent in the performance of agency's duties? An agent may not enforce a principal's promise to pay a bonus to the agent for information secured by the agents in the performance of agency duties because the principal was entitled to the information as a result of the agency. When an agency agreement does not state the amount of compensation for the agent, what will the agent receive? When an agency agreement does not state the amount of compensation for the agent may obtain reasonable or customary compensation for the services provided. Question 7. When are agents personally liable on contracts and for wrongs? Agents are personally liable when they contract in their own names and do not disclose the names of the principals, when they expressly agree to be responsible, when they exceed or materially depart from their authority, or when they engage in wrongdoing. Question 8. What is the test of when an agent has apparent authority? The test of when an agent has apparent authority is whether, on the basis of the conduct of the principal, a reasonable person would believe that the agent had the authority to make the particular contract. Question 9. How may a principal terminate the agency? The principal may terminate the agency by notifying the agent of the termination, or by taking actions that are consistent with the continuation or by taking actions that are inconsistent with the continuation of the agency. Question 10. Does death or incapacity of the principal or agent always terminate the agency? Death or incapacity of the principal or agent normally terminates the agency, but incapacity does not terminate the agency when a durable power of attorney has been executed. This concludes chapters 25, 26, and 27. Please email me the answer to question 10 of the summary review questions of chapter 27 so I know that you listened to the lecture.